This is a look at civil liberties. I decided to change up from the presentation on the board because I needed to add some things. Now remember, the definition of civil liberties is um, the personal rights of citizens. And we protect civil liberties through either the political arena, where there's an arousal of public support for principles of liberty by political and social leaders, or it can be excuse me, institutional support, in which the court's decisions on the constitutionality of laws in violation of fundamental freedoms is where, in a sense, the action takes place. So it's very simple what civil liberties is. Instituting it and protecting it is much more difficult. So let's look at where we've come from. Now, I like this because I think every time I see this cartoon, I think of the NSA and the fact that we have given it, because we're so afraid of what terrorism can do, we've given it an enormous amount of power to pry into our lives, emails, texts, phone calls, you name it. They have the ability to see it. So we know that civil liberties includes things like freedom of speech, the right to privacy, the right to be free from unreasonable searches and seizures, the right to a fair trial, the right to marry, the right to vote. We talked about that today, that some of these are stated, like freedom of speech, in the First Amendment, the right to be free from unreasonable searches and seizures of your home, and the Fourth Amendment, the right to a fair court trial, in the Sixth Amendment, the right to marry, which is a state issue, the right to vote, which is also a state issue, as well as a federal issue. They're all there. Now, let's look at the difference between civil rights and civil liberties. So we take this scenario. As an employee, you do not have the legal right to a promotion, mainly because getting a promotion is not a guaranteed civil liberty. It's simply based on your ability to do the job as a minimum requirement, in which you probably won't get a promotion, or you're very good, and therefore you're probably not the first one laid off, or you're stellar, and you do get a promotion to a different position. But if you look at it from a perspective of a female employee, you do have the right to be free from discrimination in being considered for that promotion. Oh, she can't do the job. She's a woman. You can't do that. You can't be legally denied the promotion based on, excuse me, your gender or race or disability. Up to a point. You can. Now, by choosing not to promote a female worker solely because of the employee's gender, the employer has committed a civil rights violation and has engaged in unlawful employment discrimination based on sex or gender. And so that is a civil right. We're not talking about civil rights in this chapter. We're talking about civil liberties. And so therefore, the government and the people of the United States and all of its institutions have a balancing act, let's say. Civil libertarian conflicts usually involve an individual or a group of individuals seeking to exercise certain freedoms. And it can also be, from the other way, the government seeking to keep order and preserve the rights of others. Just because excuse me, you think you have the right to do something doesn't mean that you can arbitrarily do it because you believe you have that right, because your exercise of that right may actually be infringing upon someone else's right. And so the government seeks to find a balance. Or it could even be two competing liberties. Press and petition, let's say. Press unreasonable search and seizure, let's say. It can be a number of things. So where do we come from? Well, where we've come from is a battle that raged for probably a couple hundred years once the colonies were established in the in the 17th century. And in the Constitutional Convention of 1787, the founders felt that they had written the Constitution so well that there was not a need for a Bill of Rights, which was in virtually every state constitution. And the Anti-Federalists said, no, 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 we need that because we remember that the tyranny of England, the king, terrorized for centuries the common man in England. And secondly, in order to get the Constitution ratified, the founders, and in particular Hamilton, Madison, and Jay, had to promise the people during that ratification debate that the Constitution would have, first in the first things that they did, an edition of the Bill of Rights. And they were afraid, this is a new experiment. We have a new government. We're no longer working on the Articles of Confederation. We have 3 branches of government. Not only will they work together, but will they work together to protect people or take their rights? And so there was a desire on the part of the Anti-Federalists to keep the new government from denying freedoms. And so consequently, those 4 things, the fact that Bill of Rights already existed, the desire to protect the people, the promise of ratification, and especially the memory of King George III was important. And an additional thing for the Anti-Federalists to chew on was the fact that there were certain things that were never mentioned in the Constitution. So, for instance, they were worried about the potential for denial of rights not specifically listed. The reason that the Ninth Amendment exists, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, was important to the Anti-Federalists. And during the debate on the extension of protections in the Bill of Rights to the states, James Madison, in perhaps anticipating the problems that lay ahead, made a proposal at the convention that said no state shall violate the equal rights of conscience or the freedom of the press or the trial by jury in criminal cases. It was excluded from the original Constitution, but it was added in the final Bill of Rights, that thought, not anything in the Bill of Rights that mentions the equal rights of conscience, but certainly the freedom of press and the trial by jury in criminal cases is mentioned. And in Article 4, Section 2 of the Constitution, it says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. And what that meant was, in the original Constitution, there was a grant of an extension of rights to all citizens by the federal government. And there was also an entitlement of persons entering a state to the same protections as a citizen of that state. So if you are a citizen of California, you go to New York and you're robbed, you are considered a New Yorker in this case. You're treated like a New Yorker as they try to track down the perpetrator and so on and so forth. Now, again, like we saw in the mini lecture today, the first time that this is actually considered by the court is in Barron v. Baltimore in 1833. And in Barron, what was being argued was the basis of limitations on state actions towards citizens in a state constitution. And what Barron v. Baltimore basically says is that the federal government has an inability to enforce the Bill of Rights on the state and local level. We leave that to the states. And of course, when we're looking at the history of dual federalism and marble cake federalism, we can see that marble cake federalism and the government institutions, all 3 branches, the judicial branch, the legislative branch, and the executive branch, provide remedies for what's missing at the state level under dual federalism. Now, we know that, as we did the Constitution, that there are a number of things that are enumerated in the Constitution. What we mean by that is specifically mentioned. So in Article 1, Section 10, there are no bills of attainder, which means that you cannot punish individuals without a trial in a court of law. There are no ex post facto laws, which means that you cannot punish an individual or individuals for an action not defined as a crime when that action is committed. There are no laws impairing the obligations of contracts, which means that you cannot pass a law relieving people of their debt or their contract obligations. And that brings us to the 14th Amendment. And the 14th Amendment is, in a lot of ways, almost the equal of the First Amendment in how the court treats your civil liberties today. The 14th Amendment was passed in 1868. It was one of the civil rights amendments. And the 14th Amendment, and the reason we mention it here, is that the Privileges and Immunities Clause is mentioned in the original Constitution, but the 14th Amendment restates it. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." But the court of the late 19th century didn't exactly follow the kind of line in the sand that was put down by the 14th Amendment. The slaughterhouse cases, which came 5 years after the adoption of the 14th Amendment, was a sheer failure to protect civil liberties of the former slaves from state interference. And this is about the time that the Jim Crow laws are being imposed in the states of the old Confederacy. The inclusion of due process and equal protection clauses, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Well, in 1897, there was the Chicago, Burlington, and Quincy Railroad Company versus Chicago. Should there be compensation to business for taking a property? The court supported the concept of laissez-faire. There was an extension of the interpretation to civil liberties in Gitlow v. New York in 1925, and we'll discuss that more in depth in a little bit later. It says, "We may and do assume that freedom of speech and press are among the fundamental personal rights and liberties protected by the Due Process Clause." And the two issues with the doctrine of selective incorporation of freedoms of speech and press were this. Gitlow provides a definition of the meaning of civil liberties in the Bill of Rights, and also it is the beginning of the extension of protection to the state level. So Gitlow breaks the ice. But let's look at a couple things from the First Amendment here. We'll look at this. The stated protection of certain rights in the Bill of Rights, respecting an establishment of religion or prohibiting the free exercise thereof, the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. Now, I've done a separate lecture for speech and for press and for a religion. But I wanted to discuss, therefore, some of the ones that are not going to get a separate lecture, in a sense. So let's look at Amendment 5. Now, Amendment 5, and darn it, I want to look at 4 first, and I don't have a 4 here. But let's discuss the Fourth Amendment before we get to the Fifth. The Fourth Amendment means that the government cannot engage in unreasonable search and seizure. That means that the courts have to grant a search warrant. There's the permissibility of a search for specific items with a signed paper by a judge. There's need for what we call probable cause, which means that the justification by the police on why they're suspicious has to have some validity. And the maintenance of a private individual's reasonable expectation of privacy was guaranteed by a case called Katz v. United States in 1967, which required search warrants for telephone taps and for electronic surveillance. So if the police are not there in person, you still have a reasonable expectation of privacy when you make a phone call, or when the police have set up surveillance. There has to be some sort of warrant. Now, there are a couple of exceptions to this. The approved entrance doctrine says that there's an allowance of all evidence in a trial with an approved entrance. That means that they knock and they ask to come in, and you say, okay, and they tell you that they don't have a warrant, and you say, it doesn't matter, I have nothing to hide. You kind of have given the police carte blanche to make a search of your house. Just as important is something we call the plain view doctrine. So in United States v. Ross in 1982, there was the law enforcement was given the ability to search cars, stop for traffic violations, the ability to use discovered evidence. In California v. Chirillo in 1986, there was the permission to look through holes in fences or from above the ground. But there was a prohibition at the same time on climbing the fence to look. In California v. Greenwood in 1988, there was the approval for search of garbage out for collection. Remember, I've said this before, that when you take your garbage out, you have no expectation of privacy. It's out on the curb. It's out in public. Now, the important thing for the Fourth Amendment is the exclusionary rule for evidence. There's a prohibition on the prosecution's use of illegally obtained evidence. And what this does is it halts fishing expeditions by police. And there's been an acceptance of this in federal courts since Weeks v. United States in 1914. But it was extended to the states. It was incorporated via Map v. Ohio in 1961. Though in 1984, in United States v. Leon, the good faith, the no intent to violate rights, kind of weakened Map v. Ohio a little bit. Well, we entered in good faith. It's up to the courts whether they take that or not. In Nix v. Williams in 1984, the same year, there were the acceptance of the doctrine of inevitable discovery. Well, if we kept, what they're saying is, if we kept moving along, we would have found it. And the courts have accepted that also. And then in Murray v. United States in 1988, the granting of ex post facto search warrant based on independent evidence after an initial search. They found something else. It allows them to go back and get a search warrant to cover a search that's already been made. So the exclusionary rule is really important. Now we can get to Amendment 5. Amendment 5 guarantees due process to all suspects. In Escobedo v. Illinois in 1964, the court recognized that there were reasons for inadmissibility of a confession. Number one would be denial of access to a lawyer. Number two, denial of a right against self-incrimination. In Miranda, you know that Miranda is linked to Amendment 5. There's the requirement of a specific statement or a warning to a suspect for questioning. You have the right to remain silent. Use of any statement that you make can be used as evidence against you. You have a right to an attorney, whether retained or appointed by the court because you're broke. In New York v. Quarles in 1984, though, there was a public safety exception that was accepted by the court. It was permissible to question without warning if there was an imminent threat. Interesting. Now in 6, this is a guarantee of a right to have a lawyer in criminal cases. This starts actually in 1932 with Powell v. Alabama, and it was an appeal to the Supreme Court upon the conviction of the Scottsboro Nine in Alabama state courts. And Powell said, or the court in Powell said, that a person has a right to be represented by a lawyer, and it is the duty of the state to provide a lawyer if defendants are unable. In Gideon v. Wainwright in 1963, the court expanded on that. There was a demand for the states to provide lawyers in all cases if there was a possibility of a jail sentence. And because because Gideon had very poor representation at his trial, there was, in the aftermath of his original conviction, there was an acquittal of Gideon after a new trial with a competent lawyer. And then in Pearson v. Ohio in 1988, there was a demand for states to provide lawyers for poor people in appeal cases, and we have done that. You also have the guarantee of right to a fair trial. And in 1948, this was extended to the states. And then in 1966, in Shepard v. Maxwell, and this, again, most of these cases you do not have to remember, but some of them, like Gideon, you do have to know. There was the obligation of a judge to ensure publicity during the proceedings is not injurious to the accused. And this is where a judge puts or issues a court order muzzling the attorneys in the case, law enforcement or whatever, from saying anything about it. So how do you protect the methods of protect the accused? What are the methods that the state uses? Well, first and foremost, they can change the venue, and what that means is that they can, if there's the possibility that you're not going to be able to get a fair trial because the jury pool is so poisoned, then you want to make it, or you want to change the venue to another town, another county in your state. You can't change states, but you can certainly change the place within that state. You can sequester the jury, which means that the jury listens to the trial all day. They then go to a hotel and are the guests of the state. There's the use again of the gag order, in which the judge orders that no one talk about the case to the press or to anybody else. Now, in 1988, there was a case called Arizona v. Youngblood, in which the police lost evidence. And the court said proof of bad faith on the part of police is a necessary basis for overturning a conviction. So, again, remember, in any case that the government brings as a plaintiff, the burden of proof is on the government, and it even becomes more so when you lose evidence. Now, in Amendment 7, which is pretty easy, you have a right to trial by jury in civil cases with a potential value in excess of $20, which is now $75,000. And then with Amendment 8, Amendment 8 guarantees that there's no requirement of excessive bail, there's no imposition of excessive fines, and there's no infliction of cruel and unusual punishment. This was extended to the states under the 14th Amendment in 1962. And then the cruel and unusual punishment portion of this was looked at in Furman v. Georgia in 1972, in which the court said discriminatory infliction of the death penalty is cruel and unusual. But in Gregg, 4 years later, the court said there is a constitutionality when it comes to the death penalty, with the administration under appropriate guidelines. So there's no hanging or other very deleterious ways of putting people to death, and we don't use the electric chair anymore. We're down to primarily lethal injection. And in Woodson v. North Carolina in 1976, if you want to know today why there's kind of a two separate trials, the court said in death penalty cases, there had to be two stages. One would be the trial itself. The second part would be the separate hearing for sentencing. You could have the same jury, you can have a different jury for the sentencing. And then in 1987, in McCluskey v. Kemp, the court recognized that there was a problem of racial disparity in death penalty cases. And that's what the case was about. The court said there's no proof of a flawed system in statistical evidence. I'm not sure that I would agree with that, but they're greater minds than mine. And in Thompson v. Oklahoma in 1988, the court said, or the case was about the unconstitutionality of the death penalty for juveniles under the age of 16. And pretty much the court agreed with that too. You can't put to death a person who really isn't an adult. Now, there have been some extensions. Now, we know that the original interpretation, which we talked about, comes out of Barron v. Baltimore. And we know that under the original interpretation of the Bill of Rights, it was not applied to the states. So only federal prosecutors were held to the Bill of Rights standards, not state prosecutors or local prosecutors. But we have, through Gitlow, which broke the ice, near v. Minnesota, which becomes the first case to actually impose a right on the states, we get the movement toward incorporation. Now, the 14th Amendment we've already talked about. We talked about these three clauses. I probably should have moved it around, but you have to know these three clauses. But in particular, you have to know the Due Process Clause, the Equal Protection Clause, and the fact that those two clauses have been the vehicle for incorporation of the Bill of Rights in the Constitution. And of course, incorporation again means the application of these rights to the states. And that's simply what incorporation is. Gitlow is something that we have talked about. Remember, Gitlow, despite winning his case in the court, was still kept in jail. Did New York violate his freedom of speech and press? Yes, they did, but he was still kept in jail. I'm not always cognizant of the nuances that the court has. And basically, Gitlow says, does the First Amendment apply to the states? Yes, by virtue of the liberty protected by the due process that no state shall deny. And again, they use the Due Process Clause for Gitlow. Now, selective incorporation means that the Supreme Court applied the Bill of Rights to the states on a case-by-case basis. And so there's been, as you can see in the two tables that follow this page here, that nothing has been in order. It's been scattershot. Speech, 1925, but the right to bear arms, 2008. No unreasonable search or seizure, 1949. In this here, a public right to counsel, Gideon B. Wainwright, 1963. No cruel and unusual punishment, 1962. So, to wrap this up, I just want to talk about a couple more things. There has been an extension of the Bill of Rights when it comes to sexual issues. Griswold v. Connecticut in 1965 was about the use of contraceptives, and the court established married people's rights to privacy. And in Eisenstadt v. Baird in 1972, the court said, not only do married people have a right to privacy, but single people have a right to privacy. In Roe v. Wade in 1973, the court said a woman has a right to an abortion based on the fact that there are no reasonable grounds to interfere with the privacy of reproduction. And the decision on abortion during the first two trimesters by a pregnant woman is her decision. Now that's been tightened. In Webster in 1989, there was an allowance for government restrictions on abortion services with the acceptance of government funding. In Rust, there was the establishment of a gag order on counselors and nurses in federally funded clinics which basically said that the requirement for healthcare providers to discuss abortion as an unsound method of family planning with all patients probably wasn't constitutional. Then in Casey, Pennsylvania v. Casey in 1992, the requirement of a 24-hour delay in abortion cases and the requirement of consent of one parent or judge for a minor to have an abortion was considered by the courts. Now, for the rights of homosexuals, Bowers v. Hardwick in 1986, it was about the denial of a constitutional right to be a homosexual. The court said, again, the state doesn't have any compelling interest in that. So, have there been any major instances of repression of rights in the United States? And actually, there have. The Alien and Sedition Acts of 1798, within a decade of the Constitution being passed, was the first time. Habeas corpus was suspended during the Civil War by Lincoln. A. Mitchell Palmer raided venues all over the United States to locate radicals after World War I was done. This was in the Red Scare period. The internment of Japanese Americans during World War II is another major instance of repression. And finally, the Joseph McCarthy hearings to expose communists during the Cold War was again that drama, manufactured drama of the time. So this is our look at Incorporation, and you can see how the courts, by piecemeal, have broadened the effect and the coverage of the Bill of Rights since 1790, but in particular the latter half of the 20th century has seen a very, very great enlargement of the usage or holding the states accountable to the Bill of Rights as the federal government has been held from the beginning. So this is the end of this lecture. Good night.